In the final judgment, it has not been, your name has not been recorded. That will not suffice, Mr. Gupta. The body. Oh, state's appearance have been left out. There are two states actually. One appointing authority. Yes, KMDS, but state's appearance. আজকে দেখানো যাবে সাপ্লিমেন্টারি সব দেখতে না হ্যাঁ alright, tomorrow to be mentioned. Hearing, please mention after the vacation. Salary, pension, everything. Mention after vacation. After vacation, only 2 weeks left. Mention after vacation, yes. Madam, please mention after the vacation. After the vacation, yes. When it was dismissed? 2008. 13. You can wait for some time since you could wait for 11 years. Yes. When it was dismissed? After mention after vacation, yes. Intrusion hearing. So it has to be hard. What do you want? To be included for what purpose? Under what category? Under what heading? Please mention after vacation. Yes. 56. It was the prayer for accommodation was seriously opposed by the petitioner. On that, for that it has been fixed for today. He's opposing. Look at the embarrassment of the court. The petitioner is opposing the prayer. Kindly consider that. Seriously opposed on the last occasion, considering that it has been fixed for today. Request him. 3 p.m. Yes. The 3 p.m. call. 68. Not today. You are for the petitioner. As paid for by the Article 68 record queen, as paid for by the learned advocate of the petitioner. This is continuing matter. It is continuing matter. Ordered length is a different thing. Was there direction to appear under the heading continuing matter? What do you say? Maybe. No, under the heading hearing, that was a specific thing. As paid for by the learned advocate for the petitioner, hearing of the matter stands adjourned for the day. The learned advocate for the petitioner is directed to communicate this order to the learned advocate appearing for the respondents immediately. Inform the respondents advocate. Yes, call the list. Yes, Mr. Pan, why it was fixed for as 4 orders? Oh, that direct purchase policy.
They were to 9 notice.
Direct purchase policy.
Yes.
What is your instruction, Mr.
We have petition in the direct purchase. What you must have recorded that I should show an award, and immediately no award has been passed. Proceeding as such as that.
No, I have recorded that you do not have any document in your possession to show that award has been.
In fact,
I have not recorded any final finding on that.
in fact, there is no award. And there is no 9 notice also issued. So in effect, there is a lapse in the proceeding. So what is to be discussed, what we are to argue is that what is the subsequent course to be adopted. Now, if they come up with a proposal for direct purchase, we can propose it. They say that
That is, you have to propose. It is for them to accept or not. Otherwise, Mr. Pan will say 2014, 2014. So he will not propose that.
In certain cases where Mr. Pan was appearing, he has been able to impress upon his client in the application before us. There are certain orders this court where looking at the delay, etc., it has been directed that since 80% has been already been given advance compensation, compute the remaining 20% and give it with interest of 8%. And in subsequent matter,
So, that is if his client agrees. Mr. Bandhavata, if his client agrees to that, no difficulty on that. That is up to you. Mr. Bandhavata, Mr. Pan is also a creature of instructions. So that particular petitioner might have requested Mr. or might have instructed Mr. Pan to accept that.
The court has proceeded on the basis of
May not be, Mr. Bandhavata may not be on concession, but was there any ratio decided in those judgments?
One is a division made.
Might be division based, Mr. Bandhavata. Was there any ratio decided? But if 80% has been paid, so only 20% that will suffice.
But that
What is binding, Mr. Bandhavata, is the ratio.
May basic for your lawsuit satisfaction. Thereafter, the lawsuit may decide. All the lawsuit may expose it.
Mr. Bandhavata, you have to make up your mind whether you want to go for direct land purchase policy.
I started by saying that we have no limitation in proceeding.
So what prevents you from making that submission? Mr. Pan, what instructions you have? If they offer you the compensation as per the direct land purchase policy?
Direct purchase policy does not develop compensation. It's a direct purchase from.
Yes, yes.
Now, the purchase on the basis of the purchase policy, I am in favor. This is my candidate submission before your lordship. Purchase policy says market value plus 50% solution, 50% interest. What my management is saying is completely different altogether. That 80% has been paid, so balance 20%.
No, that is saying
one course open to us.
That is saying one course.
No,
he is agreeable, Mr. Pan, he is agreeable to pay you as per the direct land purchase. That is what Mr.
I am direct purchase policy on.
Yes. Mr. Bandhavata, do you have any instructions on that? He says he is agreeable on direct land purchase policy as per that memorandum.
But we go by the scheme. Go by the scheme. The department will approve. Thereafter, Mr. Pan is aware of that. But alternatively, he will not be a instruction that he will come and apply or he is agreeable to it, etc. But your lordship may keep it after a week or a fortnight. In the meantime, let him visit our office and iron out the issues. It can be done. Then that implies they are aware of the situation and my officers are not visited.
But Mr. Pan is apprehensive. If he offers in an appeal, he will say no, we have not offered. The offer has to come by way of an affidavit from your end. Mr. Bandhavata, something has to be on record. A responsible officer of your department has to take responsibility. He has to file an affidavit with regard to this and offer.
My lordship may not disagree. It's similar to a case where it was also of 1976. After 40 years, the petitioner approached the bench and approached the court, and the court held that in view of that delay, that only 20% is to be able to give the balance of the advance compensation getting paid along with 8% interest, relying on a division making petition, both of which has gone unchallenged. My lordship is aware of this.
But I tell you, lordship, but he is talking about Nilati Chatterjee
And
and lordship had considered that judgment. Nothing has been decided in that. They are not.
Nilati Chatterjee.
Yes.
Nilati Chatterjee have considered that judgment and have passed an order.
Yes.
And notice is there, where notice has been passed in consideration of Nilati Chatterjee. Where the similar case was there, the petitioner approached after 40 years. Here approached after 39 years.
Mr. Bandyopadhyay, if you are serious in taking the point of delay, you can make your submissions on that. I will deal with that.
But I.
Because if you are on the delay, on that, you can make your submissions. On that, then I will have to decide it on merits. That is one way of looking at it. The other way is, if you have an offer of direct land purchase policy, you have to make an offer to that. Provided, unless you make an offer, he cannot accept that. Because he is not making that offer. His contention is something more than that. That is why he will not be making an offer. But he says, if you make an offer, he has instructions to accept. But unless that offer comes, his acceptance, the submission recording is neither here nor there.
They are not in a position to perform an affidavit, but today. Or there is no one to instruct me where I can give the link.
No, have you taken instructions
He
that
has
you
no difficulty in direct purchase. He has no difficulty at all in direct.
This is on instructions.
It's
Shall
on
I
instructions.
record that?
Yes.
And I will give you time to file an affidavit with regard to that.
Yes, that.
How much time you want?
From special LAO,
Where is that? Where is that memo? Do you have that memo? It is in this. Oh, in this matter, you have handed up.
That was shown to me.
Mr. Pan, do you have an extra copy because I cannot find it? No, I think in that matter, Mr. Soumitra Bandyopadhyay handed up. You have not handed up. Not in this matter, in that one. So it's a different matter, not in this matter. Wait, please give a copy because that portion will remain blank.
Market value plus 50%.
Whatever is there, what is the
Yes.
procedure that has to
Yes.
be followed? The yes, what do you have to say? Instruction, what instruction? The predecessor in interest of the petitioner or petitioners? The predecessor in interest of the petitioner. No, the petitioner claims that her father, namely Masoom Sheikh, since deceased, was the owner of RS plot number 191, corresponding to LR plot number 227. And RS plot numbers 191 and 198. Corresponding to LR plot numbers 227 and 234 respectively. Within Mauja, Joy Krishnapur, jail number 85, under police station Shamsherganj in the district of Murshidabad. For the purpose of construction, 3.1 you have annexed.
Yes.
No. Where is that? 25. For the purpose of providing proper facilities for transport and communication, namely for realignment/modification of National Highway number 34, due to construction of Farakka barrage, an order under section 3 (1) of the West Bengal Land (requisition) and Acquisition (bracket closed) Act 1948, for short Act Roman II of 1948, was issued. Full stop. The possession of the land in question was taken on
21st of December 1976.
21st of December 1976. Full stop. It is not in dispute that no notice under section 4 within bracket 1 small a bracket closed of Act 2 Roman II, Act 2 of 1948 was served either upon the predecessor in interest of the petitioner or upon the petitioner or published in the official gazette. Full stop. Mr. Bandopadhyay, Mr. Pan, learned advocate appearing for the petitioner, submits that after the expiry of Act 2 of 1948, no step was taken by the state for acquiring the property by resorting to the provisions of section 9 within bracket 3 capital A bracket closed of the Land Acquisition within bracket West Bengal Amendment bracket closed Act 1997. Full stop. Mr. Pan submits that though the land of the petitioner has been utilized for the purpose for which the order under section 3 within bracket 1 of Act 2 of 1948 was issued, but no compensation amount has been paid to the petitioner till date. Mr. Paragraph. Mr. Bandopadhyay, learned Junior Standing Counsel, submits that, in his usual fairness, submits that no notice under section 9 within bracket 3A of the Land Acquisition within bracket West Bengal Amendment bracket closed Act 1997 was served. Full stop. He further submits that no award in connection with the said plots of land has been made. Full stop. Mr. Bandopadhyay submits that the Government of West Bengal Land and Land Reforms Department Land Policy Branch issued a memorandum being number 756-LP/1A-03/14 within bracket part PT Roman 2 bracket close dated 25th February 2016, which is popularly known as Direct Land Purchase Policy from landowners by the government. He has instruction, Mr. Bandopadhyay, upon instructions, submits that the state government is willing to purchase the land directly from the petitioners in terms of the aforesaid policy. Paragraph. Mr. Pan, learned advocate appearing for the petitioner, submits that the petitioners cannot take a decision merely on the basis of the submission advanced at the bar from the learned Junior Standing Counsel for the state. In reply, Mr. Bandopadhyay prays for an accommodation to file an affidavit in that regard on or before the next date of hearing. Good stuff. Paragraph. When? Who shall file?
But, one number 3 should be. There enough.
Special land acquisition officer.
Not, but, in the meantime, we have been working to hear the petition already.
What hearing Mr. Bandyopadhyay, it will complicate. He will say,
But in fact, I can see even one of the matters after hearing.
Kindly have a look at the Roman 11 of that. I should be deprived from that. It's a purchase policy. Once we say purchase policy, there cannot be departure. I want this value.
Yes.
So this is the value 11.
Mr. Pan, if your client is agreeable to take something less,
No, my client is not a client. My experience
you want that your client visits his office.
Yes, because the matter after Mr.
No, not a binding.
Mr. Pan opposing that matter, the petitioner wait, kindly see this order.
How much time within which you can file your affidavit, that affidavit? And who shall file?
Kindly give me a fortnight time, kindly give me a word to hear it.
That if you are under the policy, you can do that.
Honor before the next date of hearing.
Mr. As paid for by Mr. Bandyopadhyay, Learned Counsel, the Special Land Acquisition Officer, Murshidabad, being the third respondent, will be at liberty to file an affidavit stating as to whether the state government is ready and willing to purchase the land directly from the writ petitioners in terms of the said policy and the time limit within which the entire process shall be concluded. Let such affidavit be filed by the third respondent. 23rd, that is 2 weeks exactly. Or can you make it by 20th? Within 20th, you can start the process within the vacation. Mr. Bandyopadhyay, if you insist, it can be done in course of this week. Only one working day less. 23rd is the next week within the 20th. On or before December 20, 2024, upon giving an advance copy of the same to the learned advocate, you can give a soft copy. Upon giving an advance copy of the same to the learned advocate on record of the petitioner, list this matter on 23rd December 2020.
Same opposition to the division में
If he approaches Mr. Bandyopadhyay, you are agreeable to receive him. You are agreeable to receive his client. If his client needs you, he will receive him.
Hard. I have not understood what is this part and why it doesn't want the petition to be hard by your client.
If you,
because I want to open my mouth.
Mr. Bandyopadhyay, maybe the other thing also. Today in the division bench, we have an experience of that. Not with regard to land acquisition. Maybe the other way around. We do not know. If accept Mr. Bandyopadhyay, Mr. Pan has heard your submission. If his client wants, you are ready and willing to receive his client. That much is accepted. If he goes, no, I have not restrained you from calling. No. Yes, call the next matter.
Now to
Yes, what happened? What is the color of money, Mr. Babu? What is the color?
See, that's why.
So what is the color I am asking? Color of money? No, color. You said color.
Color, 200 something, 500 something, different color, right? You know, it's- Can you slowly let me I place?
Order of?
Fourth November,
Yes.
second place. And the council submit that in terms of consent, because some of the advocate having some things. In support of the claim of the petitioner against Balughat municipality concern, he has received instruction from the concerned authority that the written recommendation that be issued by the advocate of the.
Where is Mr. Samanto? You are his junior. Yes, what happened to this? Let us proceed step by step. So paragraph 2, where is the compliance? Time limit has expired. Within a week from that, yes. No. Oh. Paragraph 2, what is your
But in this matter, it could be disabled.
Mr. Samanto may be leading you in this matter. The documents, if he is engaged in some other court, he should have handed up the documents to you. What the instructions, what happened? Who is for the municipality? Mr. Naik. Yes. What is your instruction? Have you received any recommendation from the state? Yes. I am asking you, have you received anything?
Recommendation and payment both are included in your action.
Yes, first recommendation.
Right.
He cannot say whether yes or no. State cannot say. No, he says no. He says we have not received.
Not in-
That is the municipality says. Oh, you also do not have instructions. Where is Mr. Naik? State, I think, has to do if the state is not here, Mr. Basu.
Since when it is going on Calcutta?
I appreciate that. He is not equipped with the instruction.
Very. That is what the court malady is getting the problem. No one is bothered. The court is asking not to appear. No instruction.
By an order dated 4th of November 2024. The submission of Mr. Samanto, learned advocate for the state, that the written recommendation by the concerned authority of the state shall be issued to the chairman Balughat Municipality was recorded. Today, when this matter is taken up for hearing, Mr. Samanto is not present. Sir, you are Mr. Kushal Bishwas. Mr. Bishwas, learned advocate, assisting Mr. Samanto, do not have any instructions in this matter. Stop. The matter has been adjourned on repeated occasions, and the respondents have not, and there is no document placed before this court till today that the order and directions contained in the order dated 4th of November 2024 has been complied with. Sir, list this matter tomorrow under the same heading. Sir, if the order dated 4th of November 2024 has not been complied with, stringent orders shall be passed. Now, this court shall be constrained to pass stringent orders tomorrow.
Maybe. Can you come to paragraph 6 of the Constitution? The municipality is there.
Yes, but the state has to first give a recommendation.
The commission is concerned.
Yes,
And you read that paragraph.
6. That is objection by the state, everything by the state. Yes, Bonga paragraph 6. Neither the state has pointed out. No allegation has been leveled.
No, can you come to paragraph 10?
10.
That will be direct.
Yes, but 11, yes, direction. I'm saying not complied with. Yes, yes. The chief engineer, municipal engineering department has to issue a written. So that has not been complied with.
Something is there. There is a specific direction to file a short affidavit indicating why.
That is also non-compliance, Mr. Basu.
No affidavit filed in respect of this. After looking, does affidavit will also pass this direction?
No, not at all, madam. They are-
No, shall file a short affidavit,
Yes.
paragraph 14.
Yes.
How I have to consider, madam, one affidavit is affirmed by some person we don't know, but it's a wrong affidavit of respondent of. We have denied from the beginning, madam, that is not the affidavit of.
All right, let it appear.
They have already filed an affidavit of last year. They have the direction to file exception, they have not filed. So whatever we have stated, that is uncontroverted.
So Shina, if they have not filed any exceptions, your that affidavit that shall be taken as non-traversed by them. I will consider that.
Then that part is not.
After producing that so-called affidavit filed in court.
Yes. They said that they have filed a short affidavit, you have not filed any exceptions to that.
That was objection then.
No.
Subsequent evidence, they have not.
Paragraph 14, there was a direction to pass short affidavit.
But I have two separate things, my lord, that time. Tomorrow the document speaks, my lord, and there is-
Release of the amount of security deposit and the supplementary bill.
Yes. What is the
That-
report?
That affidavit has not been filed.
My last
It says that
Can you record that? Yes, there is a file record that.
yes, they have not paid, brother.
This is part of the court.
Time is given, on last commission, what your document.
when have you filed that?
Last commission.
Last, what is the last? 26th November. 26th November, Mr. Basu, they have filed. It has been recorded. An affidavit in terms of the order dated 4th has been filed by the Bonga municipality. That has been filed.
And there is a last.
That is the last order.
Thereafter, you not see pass this order.
Which order?
This court.
No. That was in November. That was on 26th November. Earlier order of 4th of November, not December.
November, I am saying.
Yes, after 4th of November, they have filed an affidavit on 26th of November.
Correct. My lord,
Do you want to file any exception?
That liberty was there, they have not filed. So
not
not
file
filed.
order.
By the time they got that. They don't want to file.
Paragraph 5, you have been given a liberty.
Not necessary. Nothing given.
But
Tomorrow-
got that, madam.
Tomorrow I am keeping it.
There is no question regarding both of them. There is no question of being David Miller. They have not completed the work. They have displayed the work.
All right, that I will consider. If they have not completed the work,
They have displayed.
yes.
Get the work.
Yes, Mr. Sen.
I pointed out that they are reopening the issue. The Lord cannot do that. The Lord should take it.
I will consider that.
Yeah.
Yes, call the next matter.
But tomorrow,
Yes. Yes, where is Mr. Majumdar? He's coming. All right. I think Mr. Mujumdar has completed his argument. He was to throw some judgments. Yes.
Shows that also mention of moving to fine.
So the punishment inflicted was shockingly disproportionate to the charges even if so.
Someone, one of the eyewitnesses, she herself admitted that this lady, who was a her husband, has also get handled on conviction. So not to say that it was scuffle. Second is project hearsay evidence.
Yes.
But the incident has been object, but madam sees the deposition of witnesses of the evidence of the witnesses. Somebody has heard from somebody.
Hearsay evidence. Yes.
Somebody and Golachar something is very expensive. It's one page document. Page number 122, Lord, on the last occasion, my Lord has raised specific questions for the new launch. That who are the evidences who said or who post that this person has also been happened.
Yes.
One is Golachar sorry, one is Shravan Chand. And lawyer. My Lord, and on page 122.
Yes.
Is a named witness in the charge. From the second paragraph. Deputy Commander such and such, after spending 18 days on being reported at headquarters 3 wireless sports, RPF on 2nd February 2021. 2nd March 2021. The Deputy Commander was looking after the administration. On receiving the information of this incident on 1st March 2020, I took immediate action. Chief Commanding Officer Shubhra Major, Sub-Inspector Administration, tried to get information about the incident from the daily subordinate officer. Then the constable Golachar Shahi kept his point that our target told that Shubhi Kumar Shun's behavior with his wife. It was also informed that the sub-inspector Ruchi hits him, and he also had he raised not the his hand on Ruchi, but he did not touch him.
This was also hearsay evidence. It was also informed that. It's a hearsay evidence. Yes. No, it was also informed.
And he also had
It was also informed. So if it is hearsay, heard from someone, he is not an eyewitness. He is not an eyewitness. So this is also hearsay evidence. No, kindly read from the first line. On receiving the information of this I took immediate action. I means this Newtown Ridgepole. Chief commanding officer such and such, sub-inspector tried to get information about the incident from the daily subordinate officer. So they tried to get information. When the constable Shamui kept his point in that told about, this is Havildar. What is this? Havildar Ari. Yes, told about. It's not to him directly. Someone told him, and this was told to him by someone, not directly.
Yes.
So it's also someone saying someone has told. So no one.
Another competent person.
Yes. There was no other eyewitness to this incident, excepting these three persons who are involved. What did he say about this? Only with regard to whether Kodachand Shamui first tried to hit this person. No, 149. Sunil Kumar Suman. What did he say with regard to this? He was an eyewitness.
August 2020 on posting, and from July 2019, I was discharged in charge of men's club library, 3 Signal Bangalore. On 1st March 2020, I was in the charge of men's club. During this, Kodachand Shamui communicated with me. Then I informed Havildar regarding the same incident.
No, this he said started beating him, trying to persuade him and abuse and started beating him. 149, last 3 lines. Then I came to see that was I wanted to tell something, but he did not allow to tell anything, and he was hurling abuses, was trying to persuade him, then he abused and started beating. It should be him or me. I don't know, because there are so many mistakes in translations. Mr. Majumdar, this Sunil Kumar Suman was the eyewitness.
Undecided.
Yes.
Has been
I do not know if this is the quality of the official translation. Where is the name of the person translated? Can you get anywhere from here? No, it should be translation. The name is not there. Should be. Initial is there. But no one will take this responsibility. Give the name.
These are deposited,
Yes.
the fees.
Yes.
But then it is allotted to a translator. Then the name.
You will not know what to whom it has been allotted. You must be knowing. Can you get hold of that?
But there are two important witnesses. One is someone, the person who was allegedly beaten up. The other was his wife.
Yes.
There are two main witnesses
But they are the interested witnesses.
that
No, I was looking to an independent eyewitness. Your Learned Junior said, page 149, Sunil Kumar Shomon was an independent eyewitness.
to which the department says he can't be as an eyewitness because he had a departmental proceeding pending against him.
This is that person.
Yes. Now that if that is so, but the
All right. So let us proceed this sentence. Last 5 lines. I wanted to 149.
I wanted to tell something, but he did not allow to tell anything, and he was hurling abuses. Was trying to persuade him. He was assigned admin. That is my client. Was trying to persuade him. Then he abused and started beating him,
No,
and they
persuade. I wanted to tell something. No, we can
wanted
start
to
from.
tell something. But
Yes,
he did
I
not-
wanted to say something. That is Sunil Kumar Sumo.
Yes.
He wanted to say something to that Samui, but he did not allow to tell anything.
And he was hurling
Abuses.
SI admin, that's the requisition.
SI admin
He's the requisition.
was trying to persuade him.
Then he abused and started beating him, and they had also.
So- So this refers to this petitioner. This him refers to the petitioner.
Yes, no, then he abused and started is the person who is the complainant.
This is was tell anything was
I wanted to tell something, so the deponent, I mean the witness tried to tell something.
something to that Samui
Complainant, yes,
complainant. Yes,
but he did not allow to tell anything,
complainant did not allow to tell anything.
and he was hurling abuses.
So that was complainant was hurling abuses.
Yes. Then SI admin was trying to persuade me. That is my kind of.
I think something is missing here.
SI
Hurling abuses to SI, or it should be a full stop. Then SI was trying to persuade him,
has to be a full stop, otherwise it makes no sense.
or abuses to SI.
No, SI admin is the requisition.
Yes, was trying to persuade him.
Then
he abused and started beating him.
And they had also inflicted. Then I wanted to go near him. Then he landed blow on me also. Then I went away from there and went to 120 men's barrack and started doing my work. I went to the entertainment group and started arranging the book. Apart from that, I did not have anything.
So he was an eyewitness so far as the complainant assaulted the petitioner, but the subsequent where the allegation is that the petitioner assaulted, that he has not seen after that event.
That's it. But this evidence was disbelieved by the authorities on the ground that he was an interested witness in the sense he was proceeded against in a departmental action. Number the complainant was also proceeded in a departmental action. But there are two eyewitnesses, so to say, for the complainant. One is the complainant, the other is his wife. So for defense case is concerned, this gentleman and my position. So 2 versus 2. But I have shown you the last.
If there is, Mr. Majumdar, if there is no eyewitness to an incident of this nature, so 2 persons, the complainant and the person against whom a complaint was made with regard to an incident. Let us assume a case where there is no eyewitness. Then what is the law? How these evidence are to be, whether this evidence of these persons are to be relied upon wholly or not, or partial, what should be the guiding?
The court normally applies, but one is the credit worthiness of the witness. The second one is what does the circumstantial evidence mean? But that has once again to be correct.
First thing is the creditworthiness. If the creditworthiness stands, then if he is the sole witness, no corroboration is also necessary.
It's possible. There is no such nature. There may be no.
Some types of incident, there may not be any eyewitness and the two persons involved are only the witnesses to the, who will definitely give their respective versions of that incident.
Then comes the reportedness and the circumstantial evidence. Number there the he says that I was beaten up so heavily that I suffered bruises, I had a bleeding nose, etc. But the medical report said it is 177 to 180, so that there was no such thing as such. But page 180 is his photograph after the incident. Now, his wife says that my husband was also engaged in a scuffle with the practitioner. Now, please come to only 2 pages. But page 8. But there was an occasion when the Honorable His Excellency the Governor was to visit that place. My client was engaged in arranging for that meeting. Now, this gentleman said that somebody else had disturbed his wife or teased his wife and was asked by somebody else to make a complaint to this petitioner. So he went to lodge the complaint. There is an evidence of record that the complainant was under intoxication. Now there is an allegation that he had used abuses, but there could be, nobody has seen this. Not in a situation of this nature, there could be abuses and counter abuses. One has to put the system background of those parts.
What are the decisions you want to rely on?
Number only. Please see page 79 and page 63 first. But that's the deposition of the complainant.
63, yes.
Question 4. You have stated that the trainees of 4 or 5 ROBC as per the order of SI and Advocate Sushant Kumar Bokshi have caught you and thereafter Bokshi together assaulting to you. Can you make the trainees or can you identify them if they are produced before you? Sir, I do not know the name as I was being beaten at that time. Should be I was being beaten.
I was being beaten.
At that time, in presence of my wife, he was completely taken aback and I could not realize anything. So I do not remember their face. And please come to 79.
Yes.
Please see page 79. The 4th line from the top, and this is his wife.
Yes.
I and my husband have given the complaint in writing. Also, no step was taken. Then the commandant asked my husband whether he had laid his hand on SI Aro Kumar Bokshi. My husband told that he did it for saving himself and not to beat SI Sushant Kumar Bokshi. So this corroborates the evidence of the so-called.
So he has the defense that your client first tried to hit him. So
that
as a defense.
So that as a subordinate he has laid hands on my client is also supported by the evidence of that gentleman.
Mr. Mojumdar, what the subordinate will do if the superior hits him? He will defend himself.
Anybody who is being.
You mean to say that if the superior hits the subordinate, he will stand still?
I said that one is written.
He will try to defend.
One is not.
That is his evidence.
I said on the last occasion that there was an NEPC, but he said that I did so in defense.
Yes.
Please come to page 84.
Yes.
Commander asked my husband whether he laid his hand on SI guy. Operative Sushant Kumar Bokshi, my husband said that he laid his hand for his defense and for assaulting him because 4 Jawans had caught hold of him. Then the wife of the commandant told him. So 4 Jawans had already caught hold of this complainant. But what would this suggest? What would a normal person of ordinary prudence think?
Yes.
Who was trying to assault him?
Yes.
Now, apropos this, please see my different version at 128. And normally, you go to your lordship at the position or how the evidence has been made. But in this case, a completely different modality has been adopted by the authorities.
Yes.
In fact, the finding has been the charge has been altered. Page 128. In between the second paragraph, in between so and so, Constable Samui and number so and so Sunil Kumar Samui both came to meet me at the Minister at around 12:30 hours at the same time. Numbers went, so someone complained. Someone named someone had misbehaved with his wife. Someone seeing numbers went, so someone's behavior and use. It seemed that he was addicted to drugs and intoxicated. Since the condition of numbers, so this is someone as not good. And I was busy for sending items to the governor's program. I told numbers went, so someone to go to Inspector BBC or come to me later and further said that I would discuss this with you. First, let all items and men go to Howrah, but numbers so someone did not agree and started abusing me, mother and sister, with rude and abusive language. I was shocked to see such rude and rude behavior, and I also realized that he was in a state of intoxication. Then I just scolded him and asked him to come after a while or to go to Inspector Swenson. But numbers also someone refused to understand anything and became more and more angry. This time he started kicking and punching me with things. At that moment, trying to save myself, someone to go back to his quarter, but numbers and so someone shouted louder with abusing and went to 180 minutes for a fix.
All right. Anything more?
And please see page 56. But he said that I had blood.
56.
So he said that I had blood stain, I had a bleeding nose, I had a bleeding eye, all these things. Please
But medical report does not.
does not reveal those. Please also see the witness who had taken him to the hospital or had accompanied him for this treatment. Sir, I took answer to question number 2. Sir, I took Constable G.D. Goras and Samui with his wife and daughter aged about 4 years inside the quarter guard and made them sit in the room. Did you see any mark of injury or blood on the face of Goras and Samui? No, sir. I was about 3 meters away and I used spectacle, and at that time I did not use spectacles, so I could not see anything.
That is why he could not see. He did not have the spectacles.
I believe there is a standard eye testing done for the purpose of detention in the Reason does it make, but this matches with the, I mean, that documentary evidence.
Yes.
In the medical reports. No, not
Yes, when with regard to that injury, that medical report is there, this oral evidence may not exceed us.
possible blood might often be common knowledge. I can't, of course, spell it out in both. But the people who are ordering, I mean, guarding the boundaries or not the borders or not on the force, they are taught to use the language for some people. And this becomes a part of their daily
So, but those are the grounds for the charges framed against persons, if those languages are used.
Nowadays, it is not very uncommon when these happens go by. Just a few months back, we had this at the border. It's not quite unknown.
Yes.
But here, there is sufficient or some evidence to show that the subordinate was abusing or trying to lay his hands on his superior. Vis-a-vis the complainant, I was his superior.
All right.
Now, what do I do? Now, please come to this.
On what?
The scope of
Review. Scope of judicial review.
Scope of judicial review. Number 2, whether this would at all come within the realm of misconduct.
Yes.
Apropos of the finding of the operator, the group said that this conduct is not equal to hold such posts.
Yes.
This was in the 1979 to SCC 286.
286. Yes.
The paragraph 11 at 290.
Paragraph 11. Yes.
Code of conduct as set out in the conduct rules clearly indicates the conduct expected of a member of the service. follow that conduct which is blameworthy for the government servant in the context of conduct which would be misconduct. If a servant conducts himself in a way inconsistent with due and faithful discharge of his duty in service, it is misconduct. A disregard of an essential condition of the contract of service may constitute misconduct. This view was adopted in Sweden. The High Court has noted the definition of misconduct in Stout's Judicial Dictionary, which runs as under. Misconduct means misconduct arising from inmotive acts of negligence, errors of judgment, or innocent mistake do not constitute such misconduct. But what is negligence? But negligence is a defined tort. Has to be a defined tort. In industrial jurisprudence amongst others, habitual or gross negligence constitute misconduct but in information. In the absence of standing orders governing the employee's undertaking, unsatisfactory work was treated as misconduct in the context of discharge being assigned as punitive. In Govinda manner, the manner in which a member of the service discharged his quasi-judicial function disclosing abuse of power was treated as constituting misconduct for initiating disciplinary proceedings. A single act of omission or error of judgment would ordinarily not constitute misconduct, though if such error or omission results in serious or atrocious consequences, the same may amount to misconduct as was said by this.
রিটায়ার করে গেছে, এটা বাইরে
এখন
থেকে
রিটায়ার।
না, এই তো রিটায়ার্ড সিনিয়র ইন্টারপ্রিটিং অফিসার, এটা প্রাইভেটলি করে এটা হাইকোর্টের ট্রান্সলেশন
Right.
একদম কনফার্ম।
Mr. Majumdar, was it done privately by you? Though you might be at interpreting officer at some point of time. Yes, yes. But whether it was done privately by you or it was officially done. Stamp I find in page 212. I was asking you the name. I told you that name must appear somewhere. I found the name in 212. But whether this was done privately by you, no. Yes, that stamp is there. It's retired. Mr. Majumdar, you will find this retired. Retired senior interpreting officer. So this you have done after he has retired. It has to be privately done by you. Because this seal says retired. Sure.
সেখান থেকে ট্রান্সলেশন হয়ে আসবে, সেখানে ট্রান্সলেশন ডিপার্টমেন্ট বলে লেখা থাকে।
Into he was at point of time a interpreting officer of the court. এখন now retired.
5 বছর হয়ে রিটায়ার।
All right.
Please come to the paragraph of the paragraph and text message.
Yes.
It refers to a judgment in PH Kalani versus Air
Yes,
Force.
yes.
Where it was found that the two mistakes committed by the employee while checking the load sheets and balance charts would involve possible accident to the aircraft and possible loss of human life, and therefore the negligence involved in the context of serious consequences was treated as misconduct. But say we had that driver, that bus driver who went off to speak on the steering and the bus collided, but that was a serious act of negligence. It went up from this column. It is however difficult to believe that lack of efficiency or attainment of highest standards in discharge of duty attached to public office would ipso facto constitute misconduct. But this is exactly what the appellate authority has held. The disciplinary authority has held.
Yes.
There may be negligence in performance of duty and a lapse in performance of duty, or error of judgment in evaluating the developing situation.
So,
Maybe negligence.
lack of attainment of high standards in discharge.
He said that
This was the finding of the appellate authority.
Please recollect what I just read that paragraph once again.
Yes, I've seen that. Yes.
No, this is apropos the charges that had been leveled against him. But by no stretch of imagination, this could be a case of negligence in him. Rather, I wanted to accomplish my duty and said, don't disturb me.
So it could not also have be termed as a misconduct.
See, my conduct was not apt, but one has to also visualize the situation where I was putting. But if this is a result of provocation, then you have non-consideration, but it's quite apparent now from the evidence of record or from the materials of record that it was a case of provocation. Why should that gentleman move away from this place of record come to my place of work? I said, don't irritate me, I'm busy doing discharging my duty. He kept on nagging, maybe under the influence of alcohol. And then they had to exchange of words and this stuff.
All right.
So now this is contributory or provocative. And your Lordship has seen on the last occasion that the complainant was allowed to go scot-free. This was a clear case of insubordination against him.
Yes.
And the next one is 2006 for SCC 713.
6-4 SCC
713.
on what point?
But the extent of interference and when the court can enter. Please come to paragraph 26, serial number, the first paragraph.
Paragraph?
26.
Yes.
But the court has laid down the 5 tests when not it can be reviewed. First is, the inquiry officer is not permitted to collect any material from outside sources during the conduct of inquiry. 2. In a domestic inquiry, fairness in the procedure is a part of the principles of natural justice. 3. Exercise of discretionary power involves 2 elements, objective and subjective, and existence of the exercise of an objective element is a condition precedent for exercise of the subjective element. It is not possible to lay down any rigid rules of the principles of natural justice which depend on the facts and circumstances of each case. But the concept of fair play in action is the basis. The inquiry officer is not permitted to travel beyond the charges, and any punishment imposed on the basis of a finding which was not the subject matter of the charges is wholly illegal.
So you are on point number 5. Yes.
Please, once again, recollect the paradigm shift in the stand of the authorities. The charge is of negligence. The finding is, no, you are not fit because you are not competent to practice. And that's not because of negligence. Nobody has uttered a word in the disciplinary authorities order or in the appellate order that there was an act of negligence proved in the inquiries.
Yes.
But last, but what happens? Normally, when the court, there are judgments, but I will not come to that. When the court finds an irregularity or an illegality, normal course is to remand the matter to the authority for rectification. More so in the cases of punishment. Now, but there are cases, not by many, considering the nature of or the length of proceeding, but the lapse of time, the court can also itself substitute the grant.
This is shockingly disproportionate according to you.
But
On that,
this was really on the angle of passage of time.
yes. So you are on.
If the court is persuaded to hold that no, this is a punishment which should not have been meted out to the delinquent, then the court can in some
Usual course is that to remand it to the authorities because they are the fit persons who can decide what should be the nature of the penalty. But in certain exceptional cases, court can. Yes.
This is 1999 volume 1 CLR.
Yes,
page 341,
paragraph,
paragraph 22.
yes. Place that paragraph. Give a photocopy of that.
Yes, but here I could not find out the excessive functions. Please. Editing provided. In the light of above discussion, the appeal is dismissed as far as it relates to the setting aside of the order of punishment or dismissal, as the inquiry proceedings were proper and the charges against the respondents have been partly proved. And as the charges proved appear to be minor in nature and not vague, the disciplinary authority, that is appellant, can impose appropriate minor punishment as it deems proper in the light of the observations made in the judgment. The respondent shall be reinstated within fortnight from the date of this order, but will not be entitled back with such modification as just indicated. The appeal stands dismissed. Now, when it was pending in the case of judicial review interference, but the court went into this. The court opined that you impose a minor punishment.
Yes,
So this was the view expressed. To that extent.
yes. Whether it should be a major punishment or minor punishment. Yes. Anything more?
These are my submission.
How much time it will take? 40 minutes. So tomorrow I am keeping that. Mr. Mojumdar, learned advocate appealing for the petitioner, concludes his argument. For reply argument, fix this matter tomorrow under the same record. So Mojumdar, you can take a short note of those evidences which you have referred to. You can also prepare that which portions. Yes. Yes, call the 3 PM ma'am.
6, it's the 3 PM.
Don't look at me, look at Mr. Bhattacharya.
I have already. I don't get the files out here. I played for a few. Right? I think that is. No, the actually. I am just telling you. Why? So, apart from the fact that I cannot appear within the dunya. That is the roots. That is why the time was short. So kindly pick it up. Wednesday at 2 o'clock, as suggested by my.
So affidavit you have filed,
Yes.
Mr.
Reply.
But affidavit,
South of. When you have affected something of them, you have seen your,
but when it was filed, I don't think it's in the record.
There are many files they have to.
I'm filing the appeal. The appeal will be used by the respondent seminary. I have
The-
soft copy also.
The affidavit in opposition. The affidavit in opposition filed by the respondent number 7 and 8 and the reply thereto are taken on record. First up, the learned additional solicitor general submits that this matter be taken up on 11th Wednesday,
Yes, 11th is Wednesday.
on 11th of December 2020 Fourth. It will appear under this heading. Court will first half may not be, because first half is the division.
You know, Preliminary additional solicitor shall submit that this matter
So that-
taken upon 11th December 2022.
And such pair is not opposed by Mr. Bhattacharya, learned.
Please don't record. Suggested by him. Otherwise, if you snap me outside, better than this happening here.
First of all, as not opposed to it, as paid for by the learned additional solicitor, this matter on 11th December 2020, under the same heading. Adoption, you can make your argument.
Taking up at 2 o'clock, otherwise,
First up may not be taken up because I will be sitting in the division. If you have any difficulty, Mr. Bhattacharya is there. So at 2 PM it can be taken. If I see it. No, he says he has difficulty in the first half. In the event this court sits in the first half, he may pray for some. Yes, call the next matter.
yes, on that, for the election.
Yes. Yes, where is the state? Mr. Pan, why in all your matters the state is not appearing? Is it so or there is something? Yes. What is this? Shishwar Bandhavata, Mr. Lolit Mohan Mahato.
Opposition. Initially, they have filed an opposition, my lord. Subsequently, they were divided was given to them, my lord, to file an supplementary affidavit annexing the original one. Earlier one. My lord, they are used an affidavit.
Yes. What is the issue in the writ petition?
The issue that is, my lord, on 27th of December 1976, the position was taken over.
Act 2.
By way of petition only. Nothing was done.
No 4-1A.
No 4-1A, no steps are taken to either to convert to put it under section 3A. 9-3A. No steps are taken. Now, in between, the Act 24, 2039, they are not the head of the proceeding initiated under the Act 1940 cited.
Yes.
Praying to take since the land has been utilized, there are no other options of paying the compensation. So they have to pay the compensation upon initiating a proceeding. According to me, my lord, under the 2013 Act, because that was made, my lord, there is no other law even by which the land can be acquired. Now, they have used an affidavit. They have said that they like to place the
Supplementary affidavit in opposition.
yes, supplementary. Then affidavit to the admin.
All right. So I have to go through the annexure to the supplementary affidavit. Yes.
Now, they are the affidavit in opposition.
What is their stand?
When this affidavit was affirmed, That is on this.
Land Acquisition Act was still in force.
2015, they are saying that land acquisition is illegal.
2013. April 2013,
That was there.
that was in force.
That was in force. Now subsequently, when this was filed,
This they have annexed only that.
yes. So my lord, on that day, that was subsisting. Now,
The original
hey,
would not be fine.
Ganesh
Found in
Samanto
the-
judgment niye, Ganesh Samanto.
Yes.
Now, my lord, admittedly, no 93A. Your lordship will find that, kindly see, my lord, the paragraph, page 3, subparagraph E. Subparagraph E.
Page 3
Subparagraph E.
of the supplementary.
Page 4, paragraph 4. Can you turn to the paragraph 4 of the opposition?
Yes. No, which paragraph?
Oh,
4?
that's the kunta. Oh, my lord, sorry.
কোন বিপ মামলা করছিস?
This happens, Mr. Pan. So many briefs. This is the problem.
Now, on the supplementary affidavit, yes. In the supplementary affidavit, my lord, they have said at page 11,
Yes.
that award for 80% ad hoc land compensation amount was prepared and paid to awardees on 19/4/1989, including writ petitioner. This is wrong. This is number one, this is wrong. This cannot be any,
80% was prepared and paid, not paid.
no, paid, but this cannot be said to be the award, because this is, my lord, estimated amount. And 80% of the estimated amount.
Yes.
Now, my lord, notification under section 4(1)(a) was prepared, but publication was made or not, is not found from the available papers in the file. Now, my lord, the petitioner is the owner of plot number for area such and such. So my
Which paragraph?
next, my lord, this is, my lord, at page 6, inner page
Yes,
6.
yes, I've got that.
Next page, the petitioner is the owner of plot number 793/981 and such. So they are admitting my ownership. Now, my lord, kindly see. Paragraph 7, this is their contention. That with reference to the make 7 of the state, we are deny and dispute the allegations contained therein and state that in the Amendment Act of 1997, read with 99, though no provision of,
They propose to resort to 93A, 93B.
they are proposed to resort the 9th. That has not been done.
Yes.
So, my lord, today, that cannot be the stand. Now, my lord, in the supplementary affidavit,
So today they cannot say that I will resort to 93A, 93B.
938 3B. Moreover, my lord, now, in the supplementary affidavit filed in, my lord, this has been affirmed on 23 April 2023.
At that point of time, they could have.
Now, my lord, in between, Niladri Chatterjee judgment came into, according to them, that will apply. And another Supreme Court judgment, they are saying, on the ground of delay and laches. Now, my lord, for this, my lord, they have relied upon AIR 1964, Supreme,
Where they have relied upon.
in
I'm
paragraph
hearing
6.
this for the first time.
No, in paragraph 6, they have stated.
Paragraph 6.
Yes.
Paragraph in the opposition, they are relying upon.
In the opposition, they are saying it is submitted there in the case of Bandana Development Authority, Banda and Motilal Agrawal report in 2011 5 SCC pages 394. The Honorable Supreme Court held it is true that no limitation has been prescribed for filing a petition under Article 226 of the Constitution of India But one of the several rules of self-imposed restraint evolved upon the superior courts is that the High Court will not entertain petition filed after long lapse of time because that may adversely affect settled crystallized rights of the parties. My lord, in this case, this is not applicable, I tell your lordship. In this case, award was declared. After the declaration, the award acquisition proceedings challenged. Here, my lord.
Award was challenged. Award was questioned.
Award was questioned saying that the notification is bad, etc. etc. That's why they
The
delayed.
challenge of the award was after a belated.
After belated stage. This is number one, my lord. This over this petition and concern, and then another writ petition, reported decision they have relied upon in the state of Maharashtra, Madhya Pradesh versus Bhailal Bhai. AIR 1964, Supreme Court 1006 of the Constitution consider the effect of delay in filing the debt only. My lord, in this
See, this is not on land acquisition.
no, this is sale tax.
Area 64 Supreme Court is not on land
On the basis
acquisition.
of sale tax. This is the case related to the Sale Tax Act, not in the aspect of the which is in the land there is a continuing cause of action. And moreover, my lord, another reported decision they have online, my lord, it has also said that cannot be held by the stage of that proceeding was ever initiated under the Act of paragraph 7.
This is Nilati Chatterjee.
Nilati Chatterjee. My lord, Nilati Chatterjee, with due respect, what has been decided? In that case, 93B was issued. 401A was issued and an estimate was prepared. And I was directed to pay that estimated amount. Why my client has not challenged that? Because my client would have been get 2 lakhs. By that judgment, my client was getting 20 lakhs. Because the entire estimator was directed to pay me. And no ratio has been decided. And moreover, my the special bench judgment is there. If 401 is public is not been within the 7-day period stipulated mandatory period, this the award is not been passed, then notice for acquisition lapsed. Here, my lord, the property is under acquisition, a property under the requisition, and requisition came
That could not have been continued after the
first of
48
April
Act expired.
So on and from first.
So according to you, after expiry of the life of or after the lifetime of the 1948 Act, they are illegally possessing the property.
Illegally possession because they have not resorted the provision provided for them to save the proceedings, my lord, invoking subsection 3 capital A of
Yes.
section 9.
So no compensation paid. So according to you, they are illegally in possession of that property
Of that property.
without paying due
We
compensation.
have due compensation, my lord. And since the 2013 Act has come into force, my lord, so that Act 1 cannot be resolved, 9(3) can be invoked.
9(3), I don't think Mr. Mahato will submit that. I will now resort to 9(3).
No, please, it is not.
My lord, this is the division bench judgment of our court. My lord, bench decided by my lord Justice, Chief Justice, Chief Jyotirmoy
Mr.
Bhattacharya.
Pan, I considered this Nilati Chatterjee in one of my judgments. What happened to that after that?
No, they have not papered any appeal.
Complied with?
They are trying to comply. I have been told, my lord, they are complying with. Here, my lord, the similar situation, they took a different plea altogether that once vested cannot be divested. Section 4(1) is
This is
the.
Ganesh Samanto.
Yes. Here, my lord, the situation was cropped up and division bench held, no, you cannot take the records of 9(3) or 3B. So you have to pay a compensation under the 2013 Act. This is also the proceeding initiated under the Act 2 of 1948. Paragraph 27.
Anything more?
Listen.
Yes, Mr. Mahato.
My lord, first of all, my lord, kindly come page 23 of the writ petition.
Of the writ petition. Yes.
The requisition was made from the vendor of the petitioner, not the petitioner. And it has never been stated in the writ petition, and that has not been dealt with also in the affidavit in opposition.
Sharat Chandra,
Khatua, he was the vendor of the petitioner. He is not the petitioner. And he cannot say whether the, my lord, the proceeding, what is the continuation of the proceeding. Sharat Chandra Khatua. And he is
Mr.
not,
Mahato,
he is
did the property vest upon the state?
my lord,
Did the property vest upon the state?
my lord. I cannot say that the, my lord.
So, is there any bar to transfer? If the property has not been vested to the state, you will keep
No,
the
no, no, my
property,
lord, the transfer has been.
holding the property illegally without acquiring, and the landowner cannot transfer.
No, my
Is it
lord.
the law?
My lord, my submission is not that. He has claimed that.
Yes, I accept your submission that he is the subsequent
no.
purchaser.
He is not the subsequent purchaser. He purchased the land in the year 1966.
Yes,
But he has not brought his name in the record of rights.
yes.
And my lord.
Have you paid anything to Sharat Chandra Khatua?
My lord, 80%. My lord, assessment, ad hoc assessment.
So the property,
Sharat Chandra
property
Khatua,
did not vest.
Sharat Chandra Khatua is not the petitioner here.
Yes, I appreciate that. Sharat Chandra Khatua,
I
his
want to
name,
rely upon one decision that my lord, the
Mr. Mahato, you have admitted that in your opposition that
In
you will
opposition.
resort to 9(3)(a) and 9(3)(b),
my lord,
and you have admitted the petitioners to be the owners of land.
my lord, my lord, actually, my lord, the opposition has been, my lord, petitioner has not stated that the requisition was made from Sharat Chandra and.
You have the records with you. You have admitted. So can you now dispute his title? First. Second is the property did not vest to the state.
Property did not vest.
So can you say the original or the erstwhile owner could not have transferred subsequently?
My lord, I am not saying this, my lord. I am saying
Then-
that, my lord, it is our decision in the, my lord, the West Bengal Housing Board matters that who is in the record of rights, he will be deemed as the owner in respect of the land acquisition proceeding. The petitioner has never been.
Where has been said whose name is the record of rights? Record of rights is a document of title.
But it has been decided in the Supreme Court, my lord. Kindly see, my lord, the decision. That is, my lord, West Bengal Housing Board.
Yes. So whose name is not in the record of rights, he will not be entitled to compensation.
My lord, here it is that, my lord, it has been held that under subsection 9 of section, every entry in the record of rights shall be presumed to be correct until it is proved that the entry in the record of
That
rights
is the settled law.
settled law.
There is a presumption of correctness
But-
attached to a finally published record of rights.
In paragraph 8, it has been specifically held. It is not, it is no part of the duty of the collector to make a moving inquiry, it will be roving inquiry into the ownership of the person. Again, we do not think in a case like present one, it is for the collector to make an inquiry from registration office to find out if the land had since been sold by the recorded owner. The collector at present, in the present case, was thus justified in relying upon the official record being the record of rights as to.
Mr. Mahato, accepting your submission, you are duty bound to pay compensation to the landowner. He may be X, Y or Z. Have you paid?
80%, my lord, that is the.
80% is nothing.
Ad hoc assessment, that is.
Ad hoc is nothing. It's an estimate.
Estimate. It is.
So award has not been passed.
Ad has not been.
So if award has not been passed and you have said that you will be resorting to 9(3)(a), you have not done so. So
My lord,
1894 Act
my lord,
also stood expired.
Only,
Now what is your submission?
only submission is that, my lord, I have to take instruction whether it can be directly purchased or not.
Yes, Mr. Pan.
Let there be an instruction.
Have you taken instructions on that?
Yet, my lord, I have to take instruction.
Affidavit file.
You have to file an affidavit to that,
My lord,
that you are
the report in the form of affidavit.
not report in the form of an affidavit and affidavit.
My lord.
The you have purchased from
Yes, I have, I have annexed everything.
I have annexed everything. I have stated in
He
paragraph
has
2.
annexed the deed.
No,
He
you
has-
have purchased from Sharat Kumar Katua.
Yes.
Yes, I have said so. I have annexed the section 3 order also.
Section 3 order is in the name of Sharat Chandra.
Yes, I have said so.
Yes.
And moreover, my lord, law says not the owner, but the
You are Atal
interested,
Chandra Giri.
yes, interested person.
The petitioner claims to be the owner of plot number 793/981 and 791/982 within Mauja Kashinagar, jail number 9 under police station Kagdip in the district of 24 Parganas South, measuring an area of about 0.16 acres and 0.21 acres respectively. So stop. The a proceeding under a proceeding being proceeding being case number LA-Roman 2/40 of 1983-84 under the West Bengal Land within bracket requisition and acquisition bracket closed Act 1948 within bracket for short Act 2 Roman 2 of 1948 was initiated for the purpose of maintaining supplies and for the purpose of construction of approach road to drill site. Yes. To drill site DRIL SIT for project manager ONGC. Full stop. The
No, drill site. My lord, that is drill.
drill DRIL.
Huh.
Yes, I've said so.
Drill site.
From the order passed under section 3 within bracket 1 of Act 2 of 1948, it appears that the aforesaid plots formed form part of the schedule of the lands requisitioned for such purpose. The possession of the lands in question was taken on
My lord, that is taken on, my lord. 13th March 1984.
on March 13,
1984.
1984. Full stop. The petitioner alleges that no notice under section 4 within bracket 1 small a bracket closed of Act 2 of 1948 was served
Was published.
was published. Full stop. Was published in the official gazette.
My lord.
Full stop. Mr. Pan, learned advocate appearing for the petitioner, submits that in the meantime, the Act 2 of 1948 expired and no step was taken by the state respondent to acquire the said property by resorting to the provisions of section 9 within bracket 3A or 9 within bracket 3B, as the case may be, for acquiring the aforesaid lands. Mr. Pan submits that that the property of the petitioner has been utilized for the aforesaid purpose, but no compensation has been paid to the petitioners till date. Paragraph. Mr. Mahata, learned advocate appearing for the petition, appearing for the state, submits that the
But I am taking the point of delay, my lord, maybe.
submits that the writ petitioner has approached this court at a belated stage, as the writ petition was filed only in the month of December 2011. Full stop. Yes, Mr. Pan, have you brought those judgments on the ground of delay?
Yes.
Since he is taking this point, that has to be decided.
Vidya Devi.
And another thing, well, the 80% ad hoc assessment has been paid.
He further submits that ad hoc compensation amounting to 80% of the land value has been paid to the landowner. To the landowner.
The landowner,
To the landowner. Full
the
stop.
recorded landowner.
To the recorded owner of the said land. Full stop. Paragraph.
No,
Mr.
his incorrect statement. Kindly turn to their own affidavit. They are saying, I read
You have, it has been paid to you.
Yes, including the writ petitioner.
Full stop. All right, I am coming to that. Give me
Yes,
the
page 11, inner page 6.
page 11.
Inner page 6 of their supplementary affidavit. Award for 80% ad hoc land compensation amount was prepared and paid to the awardees of, including writ petitioner.
আচ্ছা তারপরে লিখুন Mr. Mahato further submits that that the name of the petitioner was not recorded in the record of rights and therefore he cannot claim compensation for the purpose, cannot claim compensation in respect of the aforesaid lands. Full stop. Mr. Mahato, are you relying upon any judgments on the ground of delay?
Only ground of delay, my lord, that two judgment I
I've recorded your submission.
Yes, my lord, that is, my lord, 2000 amount.
Have you brought copies of the judgments? Then I have to deal with that.
My lord, I have stated in paragraphs.
You have stated, but without the decisions, how can I deal with that?
Bandata এনেছিস বান্দাটা এনেছিস
Paragraph.
2011 এনেছিস বান্দাটা
Mr. Pan, in reply, Mr. Pan, learned advocate appearing for the petitioner, placed reliance upon a decision of the Honorable Supreme Court in the case of Vidya Devi versus State of Himachal Pradesh and others reported at 2020 2 SCC 569 in support of his contention that where is that paragraph?
Yes,
Shocks the conscience of the court. Which paragraph?
yes, paragraph 12 to 29. Paragraph 12 to 19.
বিদ্যা দেবী যেখানে
Yes, yes.
ফার্স্ট পজিশন ক্লেম করেছিল এই জাজমেন্টটা একটু দেখো কপি আছে দেখতে হবে
In support of his contention that
Paragraph,
delay and laches cannot be raised in a case of a continuing cause of action. Stop. Paragraph. Heard the learned advocates for the parties and peruse the materials placed. Full stop.
এই দেখি
আমার কাছে কপি করতে হবে
দিয়ে দিচ্ছি
The Honorable Supreme Court, in the case of Vidya Devi within bracket Supra, took note of the decision in the case of Tukaram Kana Joshi versus MIDC reported at 2013 1 SCC 353. Wherein it was observed that there are authorities which state that delay and laches extinguish the right to put forth the claim. Full stop. Most of these authorities pertain to service jurisprudence, comma, grant of compensation for a wrong done to them decades ago, comma, recovery of statutory dues, comma, claim for educational facilities and other categories of similar cases, etc. It was further observed that though it is true that there are a few authorities that lay down that delay and laches debar a citizen from seeking remedy, comma, even if his fundamental right has been violated, comma, under Article 32 or 226 of the Constitution, comma, the case at hand deals with a different scenario altogether. The Honorable Supreme, it was held therein that when the functionaries, it was held therein that in the case that in the said reported case, the functionaries of the state took over possession of the land belonging to the appellants without any sanction of law. The appellants had asked repeatedly for grant of the benefit of compensation. First stop, the state must either comply with the procedure laid down for acquisition or requisition or any other permissible statutory mode. First step, after taking note of the said decision, the Honorable Supreme Court held that condonation of delay is held that delay and laches cannot be raised in a case of a continuing cause of action, comma, or if the circumstances shock the judicial conscience of the court. Full stop. Condonation of delay is a matter of judicial discretion, comma, which must be exercised judiciously and reasonably in the facts and circumstances of a case. Full stop. It will depend upon the breach of fundamental rights, comma, and the remedy claimed, comma, and when and how the delay arose. There is no period of limitation prescribed for the courts to exercise their constitutional jurisdiction to do substantial justice. And in a case where the demand for justice is so compelling, a constitutional court would exercise its discretion with a view to promote justice and not to defeat it. Full stop. In the case on hand, a proceeding for requisition was initiated by issuance of by issuing an order passed under Section 3(1) of Act 2 of 1948. The possession was taken as far back as in the month of March 1984.
84.
As in the month of March 1984. Full stop. The authorities, for reasons best known to them, did not issue notice, did not publish notice under Section 4 within bracket 1A of Act 2 of 1948 during the lifetime of Act 2 of 1948 for acquiring the said property. Full stop. In the meantime, the Act 2 of 1948 stood expired. Full stop. Thereafter, তারপরে লিখুন the state has filed an affidavit in opposition wherein it has been admitted that the petitioner is the owner of plot number 793/981 and 791/982 for area of 0.16 acres and 0.21 acres respectively. Full stop. It has been further stated in the said affidavit that as the proceeding of land acquisition could not be completed before March 1997, the proceeding for land acquisition may be completed under section 9 within bracket 3A or 9 within bracket 3B of the Amendment Act of 1997, read with 1998. Full stop. It is not in dispute that during the, this is not in dispute. In the meantime, the Land Acquisition Act 1894 stood repealed with the coming into force of the Right to Fair Compensation পুরো এই নামটা দিয়ে দেবেন Act 2013, which came into force with effect from 1st of January 2014.
1st of January 2014.
Full stop. The authorities did not resort to the proceedings under 93A or 93B. 93B they could not have, or 93B as the case may be, during the lifetime of the 1894 Act. Full stop. It is not in dispute that the land has been utilized for the purpose for which the same was requisitioned. The
And also,
state could not have kept the property under requisition. The order, the state the order of requisition passed under section 3 within bracket 1 could not have been extended after the lifetime of Act 2 of 1948. The state is the possession of the land in question after expiry of Act 2 of 1948 without taking any steps for acquiring the same amounts to gross abuse of the powers of the state. Full stop. The state is retaining his possession of the lands in question without paying compensation to the petitioner in accordance with the provisions of the relevant statute. Full stop. In the considered view of this, this court is therefore of the considered view that discretion, in the facts of this case, this court is inclined to exercise discretion in favor of the petitioner as the demand for justice is very compelling and such discretion is being exercised by this court with a view to promote justice. Full stop. The state cannot deprive a citizen of his property without paying compensation in accordance with the relevant statute. Full stop. at this stage, it would be relevant to take note of the decision of the Honorable Division Bench in the case of State of West Bengal and others versus Ganesh Samanto, reported at 2014 4 WBLR within bracket Cal bracket closed 996.
SLB paper, SLB dismissed.
996, wherein the Honorable Division Bench, after taking note of the fact now, after noting the decision of the special bench in the case of State of West Bengal versus Shobita Mondol, reported at 2011 3 CHN within bracket Cal 555. Observed that the state government could have completed the acquisition proceedings by applying the provision contained in section 9 within bracket 3A of the Land Acquisition Act. But in view of the subsequent development in the land acquisition laws with the enactment of the right to fair compensation and transparency in land acquisition, Rehabilitation and Resettlement Act of 2013, and particularly in view of section 24 within bracket 1 within bracket A of the said act, the state could not have completed the acquisition proceeding by following section 9 within bracket 3A of the Land Acquisition Act, which has since been repealed. After noting the aforesaid provisions, the Honorable Division Bench held that the state respondents are required to complete the acquisition proceeding by following the relevant provision of the right to fair compensation, relevant provision of the 2013 Act. যেখানে আগে বলেছি না, right to লিখে দেবেন for short, the 2013 Act. Full stop. Yes, Mr. Mahato, now I am recording your that submission, direct land policy. At this stage, Mr. Mahato, learned advocate appearing for the state, submits that the petitioner can consider the proposal of the state for direct purchase of the land in question by the state respondent. Full stop. In reply to such suggestion of Mr. Mahata, Mr. Pan, learned advocate for the petitioner, submits that if a concrete proposal from the end of a responsible officer of the state government comes to the petitioner with regard to purchase of land directly from the petitioners, the petitioner will consider the same.
In terms of the policy.
Will consider the same. আচ্ছা, ওই যে এখানে বললাম যেটা মিস্টার মাহাতো যেটা বললাম না, এখানে কি বললাম একটু বলুন তো। সাবমিটস দ্যাট, ঠিক এইটার আগে মিস্টার পানের সাবমিশনের ঠিক আগে বলে অ্যাট দিস স্টেজ বলে শুনবেন। If a না তার আগে লিখুন directly from the petitioner in accordance with the direct land policy contained in, give the memo number in that matter.
In that matter.
In what is the item number?
Item number.
আগের একটা item number সেইখানে
73, না 73 এটা।
এটা।
1, item number 1.
1 or 2?
1. Today's item number 1. For orders, item
Orders
number 1.
item number 1 এ আছে ওই ফাইলে। কি বললাম? wide memo dated ওইখানে দেখবেন পুরো পার্টিকুলার্স বলে দেওয়া রয়েছে। Mr. Pan,
1.
ওই the said memo, the petitioner shall consider the same. Full stop.
Solo.
Mr. Mahatal, honored advocate for the state, prays for some time to file an affidavit by a responsible officer of the state in that regard. Full stop. As prayed for by Mr. Mahatal, honored advocate, who shall file the affidavit?
Collector.
Land acquisition, special land acquisition officer,
Respondent number 3.
respondent number 3.
The special land acquisition officer being the special land acquisition officer, 24 Pargana South being the third respondent, shall file an affidavit as to whether the state is agreeable to purchase the land directly from the petitioner in terms of the aforesaid memo, and shall also specifically state in the said affidavit the time within which the entire process shall be concluded. Let such affidavit be filed on or before December 20.
My lord, after vacation.
Why?
My lord, after vacation, because
Are-
my lord, ONGC is the,
No,
ONGC is the, my lord, the requiring body. My lord,
ফোনে কথা বলে যাবে তো।
money has to be collected from the ONGC.
that
But-
he will, no, only with regard to offer, he has to consider. I am not saying that you have to pay within that.
Yes.
Offer has to come. You have to first make an offer in that affidavit and a time only for the filing of the affidavit, nothing more than that. On or before December 20, 2024. First up, list this matter on December 23, 2024. Under the heading for orders.
My lord, let my land friend also communicate this order to the requiring body.
How could I know who is the required-
Everything is in your control.
See,
Mr. Mahato, they will not understand. Everything is in your
Yes.
control.
ONGC is not our control, my lord.
ফোনে
The
কথা হবে।
requiring body,
Yes.
you will have to collect funds from them,
Yes.
or you shall be directed to comply, because I am bound by the division bench.
Yes.
Since you have made that offer, I have given you that relaxation. Otherwise, I will follow Ganesh Samanto and I will direct you to take steps.
And tested up to Supreme Court.
Yes, call the next matter.
74. Lord, 74, this matter, my lord. I'm praying for that.
74, what do you want?
The matter will be taken up after vacation because this.
As paid for, you are for the petitioner.
Yes.
As paid for by the learned advocate for the petitioner, list this matter after reopening of this court after 6 months vacation. Next, why so many applications? What for?
Lord, I'm not the petitioner.
You are not to brief. All right, call the next matter.
75.
75,
Petitioner,
there are two matters. In one, I am for the petitioner, and the other, I am for the respondent.
in which you are for the petitioner.
I am petitioner in 13,605.
In 13,000,
605.
so you are the estate of Raghunath Ji Thakur.
Yes, yes, yes.
Who is opposing you?
There are private respondent as also the municipal authority.
Affidavits filed.
Yes, yes.
The other petitioner, who is the for the other petitioner? Nobody is here, Mr. Bhattacharyya. What can be done? What is your suggestion? To take up your matter ex parte.
That will not, sir. They again, they will come
So not today.
only as your lordship.
Mr. Bhattacharyya.
Nobody appears, your lordship kindly record, nobody appears on behalf of.
Mr. Bhattacharyya, learned advocate, appears for the petitioner in duto petition ache, petitioner in WPA 13605 of 2009. First up, none appears for the petitioner in WPA 5580 of 2016. The state is also not represented,
Municipality is there.
Municipal, not
State
state.
and the municipality are not.
State is not there, sir.
Why state is not there?
Just a minute, man, let me check.
Oh, state is not a party. No.
Hmm.
76, I find state is a party.
Just a minute.
State and the
Municipal authority.
Hooghly Chinsura municipality.
Yes, yes.
It's not Chinsura municipality only.
At that point of time, it was
None appears for the state or the municipality.
no accommodation also is possible.
Full stop. What is this matter, Mr. Bhattacharya?
But this is a devoted property. Practically, the dispute between the father. One brother is on one side and mother and other sister.
What do you want?
And I want setting aside the demolition order.
You are suffering an order of demolition.
Yes.
You have made an illegal construction. Mr.
No,
Bhattacharya.
not at all. This is not illegal construction. This is not illegal.
You have said demolition. It has to be illegal.
No.
An authorized construction has.
Yes, yes, yes. According to them, this is illegal because, my lord, based on which the allegation was made.
218 is there, Mr. Bhattacharya.
Yes, madam. But
So you can challenge that in 218
that,
subsection.
your lordship, after hearing me, will decide, madam. This is a case they have decided the issue that since I obtained the plan on the basis of the power of attorney and the attorney was died, that is why subsequently that was not the complaint. That issue is pending before the civil court. On the basis of only that finding,
The plan was not revoked. That could have been a ground for revocation or
that
cancellation.
plan was not revoked.
Yes. But order of demolition, you could have challenged in 218 subsection.
That order of demolition I have challenged in this.
Why in read? Why not in 218
I
subsection
got
3?
for-
Why not?
That-
Alternative efficacious remedy, go there.
That
Go there. I am giving you liberty.
tomorrow morning, day after tomorrow. Today,
Tomorrow you will not be available.
because today there are social functions. That is why I will not be able to go.
All right.
Day after-
Next. Day after tomorrow. Yes, next.
27.
77, my lord, I beg to appear on behalf of the petitioner, my lord. My lord, on the last occasion when this matter was taken up, my lord was kind enough to direct us to serve a notice upon the respondent
77, 78, 79, 80.
till 80.
Four
Till 80.
matters.
4 matters. My lord, 77, 80 can be taken up together because both these matters are similar in nature. And 79 and 78 and 79, my lord, these are also the facts are same. The orders are different. My lord, may I just place 77 first?
Who is for the respondent?
My lord, I am for the private respondent number 8.
And who is the
My lord, Senapati, the bank and as well as the internal complaint committee is represented by Mr. Sudhir Kumar Senapati. We have served them notice also and he called us acknowledging the receipt of the notice also.
where is
My lord, may I just start? Then again I will serve and come back tomorrow.
Mr. Chakravarti? How that will help?
My lord,
Of the other side.
my lord, the respondent knows what will be my submissions because it is in the reply as well as in the petition.
No,
I
no.
will only what
Mr. Chakravarti, that is neither here nor there.
my lord, the difficulty will be that, my lord, we are suffering because of a frivolous, botched up investigation. We were punished, and that punishment has resulted in not only stigma but also our service career has been affected. And my lord, I have only one.
What was the recommendation of the committee?
My lord, the recommendation of the committee, my lord, after holding that the charges against me under sexual harassment has not been proved, has recommended for initiation of disciplinary proceedings. The act or this
Not been proved, recommended for disciplinary inquiry.
absolutely, my lord, absolutely.
Huh?
My lord, I am just relying upon that relevant portion. Even the inquiry, my lord, I am going to show from the factual aspects that none of the procedures were followed which has been envisaged in the service rules or in the act or the rules. My lord, kindly just take note of page 54.
But Mr. Chakravarti, there is an appeal provided under the statute against.
My lord, my lord, I will also argue on the point that such was the investigation, my lord. I will rely upon Whirlpool, also the latest judgment. that fundamental rights of mine has been given a go-ahead. It does not matter to them when this proceeding was conducted with them. It was proceeded with the absolute closed mind.
But Mr. Chakraborty, that is one thing. But you have filed this writ petition in 2021. If you had preferred an appeal, that would have been disposed of.
My lord, they in their reply has stated
One
on
thing
their
that you can prefer a writ petition in view of existence of alternative remedy, but the fact remains 3 years here, it's pending. Appeal could have been disposed of much.
My lord, what they have stated when I asked them,
And you could have taken this point in the appeal also.
my lord, what I have stated,
Or in taking this point in the appeal.
my lord, I want to try my luck before this honorable court. My lord, first because, my lord, may I just state the facts in brief? My lord, what has happened is that on 7th March 2020, my lord, I will rely upon the documents. First, I want to apprise my lord of the facts in a nutshell. My lord, 7th March 2020, there was a holy celebration in the Bhawanipur branch of the respondent bank. My lord, everybody participated in the holy. My lord,
Please show me that there is a finding that there is
not proved, but recommendation.
but it has been recommended.
Yes, my lord. Kindly first take note of then page 54. It starts from page 52. My lord, first kindly take note of page 52 once.
Yes.
My lord, it is one letter issued by the respondent number 2, happens to be the presiding officer. My lord, it is dated 9/11/2020. My lord, may I just read? It was the forwarding letter delivering the recommendation. The second paragraph is very relevant. Why I am relying upon this committee is saying that you file an appeal to me. My lord, if my lord wants take note of the second paragraph, as such, now the corrections are being made and incorporated. The revised recommendation is being submitted. In case of any grievances or aggrieved against the recommendation of the internal complaint committee, you can submit an appeal in writing to the committee. In accordance with the central's office circular dated 4th August 2024. Well, now it starts from 53.
Is it page 54? The finding second paragraph.
Yes, my lord. Yes, my lord. Yes, my lord. Yes, my lord. You held, my lord has already seen the, but for my sake, I am just reading that relevant. Her actions, the fourth line, her actions, though not desirable at that juncture, do not come under the scope of sexual harassment, but certainly deserves recommendation. My lord, kindly take note of the very next paragraph, point number 4. Page 55, point number 4.
No, only the direction has been passed that posted or deputed to other branches. No,
my lord. Point number 4, page 55. Initiation of disciplinary action. Point number 4, my lord. My lord has seen that point number 4, third paragraph from the top. Debulina Basu, that is the petitioner. 55. I am relying upon page 55. Initiation of disciplinary proceedings in a misconduct, as a misconduct in accordance with the provisions of the disciplinary action and procedure specified in the. My lord, that is annexed. That is annexed to the petition. That is annexed to the petition.
Show me that.
My lord, first kindly take note of page 114.
114.
Yes, ma'am. But it is a case where the inquiry report was also not given to me. My lord, this has to be read with 129 because 129 is the rules of this respondent bank. It is just copy paste of that act. My lord, may I just read? Section 13 I will be first relying upon. My lord has got 114.
No, section 13 of the act.
Yes, my lord. On completion of an inquiry under this act, the internal committee or the local committee, as the case may be,
Subsection 3, according to you,
where the internal committee or the local committee, as the case may be, arrives at the conclusion that, my lord, this is proved. My lord,
yes,
what will happen if it is not proved? That is 2.
subsection
Where the internal committee or the local committee,
to be taken.
my lord, it shall recommend to the employer, not required to be taken. Now, my lord, once see the,
Mr. Chakravarti, that is the short submission of yours.
my lord, 129 also says the same thing.
Where is the respondent?
My lord, I will again inform them over telephone today. If my lord keeps it under the continuing matter, I can bring them.
What is the stage of the disciplinary proceeding?
We have been punished. I have been given the punishment of censure.
Punishment has been given.
But
What-
court has protected me to the extent that the punishment order should not be given effect to without the leave of the court. They have not filed any application stating that leave be granted to inflict the order of punishment. So, my lord, I will.
Mr. Chakravarti, have you now challenged the order of the disciplinary authority?
In this regard, I have my submission will be, my lord, if the initial action is not in consonance with the law.
I follow that. Have you brought on record the order of the disciplinary authority?
I have, my lord. I have. In the reply of mine.
In the reply.
My lord, none of the procedure which has been envisaged in the act has been followed. More or less.
For the private respondent, what do you have to submit? What is your submission? Can a recommendation be made to initiate a disciplinary proceeding when the ICC finds that the allegation is not proved?
If my lord permits, I may take instructions from my. If my lord permits, I may take instructions and come back shortly.
Ashun. Mr. Chakravarti, learned advocate appearing for the petitioner. The others matters are also same. Same
77 and 80 are same. There were not proved initiation of disciplinary proceedings.
Yes.
78 and 79, here charges were proved and initiation of
Charges were proved that will not fall in this category.
In this category, that has to be, my lord.
It has been clubbed, Mr. Chakravarti.
Because the facts are all same. All same.
Facts may be same, but these points are not same.
My lord, points are same. Points are also same because I will show to my lord.
Charges are proved. Here you are saying charges are not being proved.
My lord, why I have these are clubbed together? Because, my lord, the procedure that has been laid down, none was followed. None.
Ashwin, with regard to item numbers?
77 and 80, my lord.
77 or 80. Mr. Chakravarti, learned advocate appearing for the petitioner submits that the Internal Complaints Committee in the order impugned in this writ petition, that is the order impugned.
Yes, my lord.
The Internal Complaint Committee in the impugned order recommended initiation of disciplinary proceedings against the petitioner in spite of a specific finding being recorded by such committee that the actions of the petitioner do not come under the scope of sexual harassment. Full stop. The question would be, after returning such a finding, the ICC could recommend disciplinary action to be initiated. Full stop. None appears for the respondent bank. The learned advocate appearing for the private respondent seeks time to take instructions in this regard. List this matter in the next week.
As per my lord's convenience, my lord.
List this matter in the next week. It হবে 77 or 80. ঠিক আছে?
My lord, sorry, I'm extremely sorry. My lord, except 16th and 17th. I'm sorry. I have some personal engagement, my lord. 16th and 17th.
Ask your junior to mention, let it appear in the next week. This is 77 and 80. It is, acha, ekdom upore likhben. Though these writ petitions are tagged together, but after hearing Mr. Chakraborty, learned advocate for the petitioner, this court finds that the issues involved in item number 78 and 79 are slightly different from the issues involved in item number 77 and 80. Or writ petitioner number ta kore deben. So, sir, in view thereof, let item number 78 and 79 appears separately in the list on the next day.
My lord, will it be in this? My lord, will it be in the same heading or under the continuing hearing matters?
Same, because the other side has not been, not substantially hard, Mr. Chakraborty. Yes, next.
Grateful, my lord.
81 with 82.
That in these matters, I am appearing for the respondent, West Bengal State Cooperative Agriculture and Rural Development Bank Limited.
Yes, you are the answering respondent.
Yes, my lord.
My lord, the difficulty is that, my lord.
You are for the petitioner.
Petitioner, but my reply, I am told that this is a transfer, the reply after I gone through the.
You want to file reply to the opposition.
It has been affirmed.
Reply has been affirmed.
Affirmed, it has been filed. I am not in position to hand over the reply because of the fact, my lord.
So you want time to file reply? When?
7 days. 7 days.
But the
My lord, may I be allowed to file my affidavit in oppositions in
The
these two matters?
the affidavit in opposition filed in court today is taken on record. Why this has been tagged? Why?
Both are
They're similar matters.
Affidavits in opposition করে দেবেন. Filed by the respondent is taken on record.
Respondent bank, my lord.
Respondent bank is taken on record. The learned advocate, Mr. Debbarman, learned advocate appearing for the petitioner, seeks extension of time to file the affidavit in reply. Let such affidavit in reply be filed within a week from date. List this matter after a week under the same heading. Next.
That 83.
Yes.
Yes,
What do you want?
Tweet.
You are for the petitioner.
I'm for the, but I know
What do you
that
want?
Mr. Suman Dev for the respondent state this.
No, I'm asking you, what do you want?
But this is the a selection interview was that is in the year 19 on 5th October 1999
For the post of
for the post of my lord assistant teacher in history
1999.
1919.
You are still not
We could
appointed.
Nobody could not. They are obstructed, could not appear. At
So
the,
now what is your age, Mr.
what I'm
Sajati?
saying, only one person, the son of
Your
him.
age now. What is your age? Not your age. The client say. 99, you wanted an
99 years.
appointment. today you are in 2024. What is the age of your client?
At this stage, today now 60, I think now.
So
One man panel.
anything,
That
Mr.
is matter is
Bhattacharjee,
pending.
anything
No,
written
but
in
I'm
this?
saying.
Well,
But I-
What is the age of superannuation? 60?
Well, I am.
I'm saying
working
it.
there- I am
I'm saying-
working there since 2014
No, I'm saying here, Pansi.
and the matter has. been-
One man panel was, I challenge the one man panel.
Mr. Bhattacharjee, I'm asking you,
Yes.
even if you succeed, what you will get? He will
59
lose
years-
his job. He will not get your job.
But his client has already entered, he's doing, working in the school.
Bhattacharjee, I'm asking you,
Yes,
even if the writ petition is allowed, he will lose his job,
Yes.
but your client will not get job.
but his approval has,
No, no.
appointment has been approved subject to return of the writ
No,
application.
no, thereafter approval.
Mr.
has been
Bhattacharjee, I
given.
appreciate that.
Yes,
If the writ petition is allowed,
yes.
what you will get today? That is why I'm asking you. That is why I asked you, what is your age now?
No,
Only,
he's a para
Mara,
teacher.
only see superannuation, I think, my lord, 3 or
Superannuation.
4 months left. Only 3 or 4 months.
So
You will attend.
you will also not get pension, nothing.
Yeah.
What you will get? Are you serious?
I know, Mara, serious. But can you see?
I'm asking you, are you serious in this matter?
Yes,
This
yes.
is the matter of 2000. What you will get?
That is the scenario, what I'm saying. My learned friend clients also challenged the one man panel. A panel was prepared to one man panel.
No, no,
He has the,
I have
I am
not challenged.
respond number 8,
I have
he is the
not
son of
challenged.
the headmaster.
I have
But
not challenged. I
They
said.
say matter went
One
up to
man panel is
division bench. The division bench, there is no, the candidate has no fault for preparing the one man panel. Thereafter, against that order, in the, that was in the original side jurisdiction. My clients went to the almost Supreme Court also. The almost Supreme Court withdraw the SNP, my lord.
So how? What reasons, my lord?
But in spite of that, my lord, my writ petition, at that point of time, that was entertained, my lord. That is a direction for filing an affidavit, and that was the ad interim order also subject to result of the application.
All right. So where is Mr. De? Mr. De Shumon De is appearing.
Yes. That is why I want to see, my lord. The one man panel, the school authority can prepare one man
But
panel.
I'm making it not today.
That is against some rules or your laws.
Right.
Only one man panel. And he was the respondent, he is the son of the headmaster.
Take instructions.
That is
from-
the reason.
Mr. Bhattacharjee, take instructions from your client, whether your client is very serious. in
But
this.
I had a talk with my client also. My client also, he wants it in judgment. And so one man panel is valid or not. That is the reason.
Mr. Bhattacharjee.
But you also can decide it.
Well, that has already
All
been
right.
decided by the division.
All
bench.
right. Not today. Inform Mr. De.
In that matter, my client was not a party. That he
All right.
filed a review application also.
All right. Conserve your energy for the next day. Yes. Call the next matter.
I filed my reply also.
Reply you are filing.
Yes, I have filed. Already filed.
Yes. Call the next matter.
Sir, I informed Mr. They also.
Yes.
Other day, you also had this matter and asked Mr. They also to take this step. চুপ করুন না।
Yes. Yes. Call the next matter.
But he is submitting, but he continue.
না না আমি বলছি যে উঠে গেছে
Yes. Yes. Call the
But
next
you're
matter.
also not accepting any mentioning for.
আবার মেনশনিং
This is not the mentioning time, Mr.
No,
Bhattacharjee.
no,
অদ্ভুত কথা
Yes. Acquisition.
No, well, this is the dispute pertain to the Metro Railway's operation and
Railway.
Metro Railway and Works Act.
All right. 4:30. It will be called on from this matter.
Yes. Obliged.
Yes, Mr. Laidi. Next matter is yours.
After somewhere.
Yes.
So from tomorrow, this will be called. So tomorrow
Inform your other side.
Yes, I will inform my other side. Okay. হ্যাঁ ঠিক আছে